Thanks for joining us today. We're excited to be here with you on Freshly Financial. I am your host, Adam Keller with Three Oaks Advisory Group. And today we will be diving into the infinitely deep conversation around estate planning. We'll keep it bite sized and focus on titling of joint assets, specifically in the great state of Texas. And joining us will be an expert in the area, Ricardo Ceballos. He's an attorney licensed in Texas, licensed in his native El Salvador, but also he spent some time with the United Nations. So inevitably, we're going to learn something. We hope you join us today for our conversation on Freshly Financial. Welcome. We are so glad that you are here with us today on the inaugural episode of Freshly Financial Organic Wealth Management Conversations. And we're just going to start out and swing for the fences in the beginning. We've got a pretty heavy hitter with us today, Ricardo Ceballos. I'll tell you a little bit about him in a second. I am your host, Adam Keller, with Three Oaks Wealth Management. I am a certified financial planner. I'm an accredited estate planner. So since I'm hosting, I'm going to be selfish, and we are delving into the realm of estate planning today. So again, let me tell you a little bit about our guest, Ricardo Ceballos. So he is an attorney here in the Dallas-Fort Worth area where I am located as well. And he is not only licensed to practice in the state of Texas, which in his words is big enough as it is, but also in his home native country of El Salvador. Ricardo and his wife have 5 children. When he came to the United States, he spent some time working with the United Nations. He's told me everything that we are speaking of today is strictly on the record. Nothing is covert. So it's all good. You're not hearing any top secret information today. But we are going to be talking about something that I find to be very pertinent in so many conversations. In our group, we love to collaborate with outside professionals because we find ourselves to be experts in nothing. So we're glad to have Ricardo here with us today. Ricardo, tell us a little bit about yourself before we jump into what our topic will be.
Sure, Adam. First, thank you for having me here. It's a great pleasure and honor to share the mic with you. Yes, I came to the States many years ago, and at the beginning I thought, I'm going to go back to El Salvador. But then as the more I delved into the law here, I decided to stay and get a JD and, pass the bar, which was very difficult being English my second language, but I really enjoy it. And I started doing mergers and acquisitions. I worked for the UN too, as you mentioned. But then I found, I think, my calling by finding estate planning and helping families navigate through different decisions that they have to make in order for them to take care of their families and their loved ones when they're not around anymore. So I really enjoy what I do. And again, thanks a lot for having me.
You're most welcome. And the name is Freshly Financial. Ricardo and I are freshly off of working on a case together that ties into the topic today, which is joint titling of assets. What does a married couple do when they're setting up a new account, acquiring a new piece of real estate? How do they title the asset from an ownership standpoint? And there are numerous ways to title it within the joint realm. So understanding a little bit of that becomes important, but also just the realization that such a basic building block of estate planning is essential to maintaining the integrity of your estate plan, but also can be very detrimental and actually messing with what we call the dispositive features of your estate plan, a fancy term for how assets get passed when you pass. So, Ricardo, maybe we can start from the basics. And we're in Texas, right? Every state has its own intestacy laws. So we're not going to venture insights into Louisiana or New York, the home of your favorite baseball team, right? But talk to me a little bit about in Texas. Typically, we see on applications, we can title assets joint tenants in common, joint tenants with rights of survivorship. And then maybe every now and then on a more universal application, it might say something like tenancy by the entirety. Tell us a little bit about the difference in those different types of joint ownership.
Yes. Let me start by sharing something that happens to me very often because I deal with families that have migrated to Texas, and many times in their home countries, a married couple automatically the survivor of the two inherits the whole asset and it's automatic. You just need to show the death certificate and it's automatic. And I think many people that I've talked to assume that that's the case always. And in Texas, we have community property. So you hear this a lot, everything is owned 50-50. So the next assumption that they make is, okay, if my wife and I own an asset 50-50, so that means that when one of us passes, the other one is going to own 100, right? That's the logic. But I think whenever a couple is opening an account, any type of financial account, they have to understand what the consequence is going to be of how they're going to title it. And the issue here is that many times the person that they have across the desk might not be able to give them, of course, legal advice because they're not an attorney. They might have just a form that they have to check. They're doing their best job to try to accommodate for the couple that is in front of them as their client or potential client at that time, opening an account. But they have to make sure that whatever option they choose is the one that they know will have the effect that they want. So they should start with the end in mind and then go back and see if that's the way they want it to happen at the end of the day. So one of the first questions that we ask our potential clients is, give us a list of the assets that you have, including all your accounts, and tell us how they are titled. And many times they assume that, I think it's in my name, I think it's in her name, I think it's joint. And I said, no. Go back to the institution where you opened it. Make sure that it's the way you're telling me it's titled. And that way we will find out. And this is the word of the year for me. It's alignment. It's so many plans fail because of poor alignment. It's not, the documents are great. They're, perfectly drafted, but the alignment of all the assets was not appropriate, was not right. So some asset might be left out. But anyway, going back to your question, I just wanted to get that out because that's going to be, you're probably going to hear me repeat this over and over because I think it's very important. So we have different ways in which a couple can set up accounts. In Texas, generally couples tend to think everything's joint, but there's when you look at the forms that different banks use, and we had access to a couple of those before we did this podcast. Joint tenancy with right of survivorship. Whenever you see those words, right of survivorship, be aware that that means that whoever survives the other person will receive the asset. So make sure that if that's what you want, it has to say right of survivorship, whether you're married or not. If it says with right of survivorship, it can be two brothers or two siblings. They can be joint tenants with right of survivorship. So, because sometimes it depends on every family, but they might not have any children. So they say, okay, the first one of us to die, it's only fair that this asset was left to us by our parents, that the other one gets 100% of it if one passes before the other. So that's the first thing that you should look for. If it says right of survivorship, that's what it means. So joint tenancy, what it means is, let's say we both own an asset, but it's not clear who owns what part of the asset. So I try to imagine it like a picture that is half red, half blue, but the colors are faded in between them. So you can see that there's two colors. You can see that there's two owners, but you can't see exactly which part belongs to who. So that's the first type, joint tenancy. That's what it means. When you move to tenancy in common, the same example, you have a painting, red and blue, but you can see a clear line. So you know exactly. They either own 50-50, 60-40. So it's very clear who owns what. And the tenancy by entirety, which is something that we were talking about before, it's not recognized by Texas. And that's something that it's a common law, a concept that works perfectly well in other states, and it's used for married couples, but we don't have that here in Texas. Here in Texas, by the Constitution, there's community property and separate property. So, and we'll talk
Mhm.
about that too, because that's going to, I think it's going to give you a different outcome depending on how the couple manages the asset. And that's another thing. So whenever we see an asset that is owned by a married couple, first we have to ask ourselves as attorneys, is it community property or is it separate property? And even if it's community property, it might be separately managed by one person in the marriage. So, but that's the first approach, if it's community or separate property, because that's also going to determine the outcome. So it's, I know many, many of our listeners and people that are going to watch this are thinking, there goes the attorney, muddling things up. It's unfortunately it's a case by case, so that's why we like to make sure that we understand and our clients understand how they own the assets, because a slight, like I tell them all the time, even if you have your own account, if it's in your name, if it's money you inherited from your parents, if you start commingling those funds, then you're blurring the line. So that's when creditors might have an advantage. So
Mhm.
anyway, so going back, we said joint tenancy is where there's no clear separation. Tenancy in common, there's a clear separation, who owns what. Then we said tenancy by entirety is not applicable in Texas. So in Texas, we have community property with right of survivorship, which is something very local to our law. When a married couple both recognize that that is community property and they decide we want the right of survivorship. For example, a couple owns a house, and I just saw this in a recent case that we had at the office. A couple owns the house, they sign an agreement because all of this has to be in writing. That's why I was asking you, whenever a financial institution opens an account, there should be a contract that goes hand in hand with the designation that is chosen, because it has to be in writing. The right of survivorship has to be very clear in writing. So going back to community property with right of survivorship, the couple recognizes that it's community property, but they want the property to go 100% or consolidate 100% in the surviving spouse when one passes. This helps a lot because you can do this outside probate or even without a will. So that's why we are very interested in understanding how they own the assets, because sometimes people come to the office and say, I need a trust. And I'm like, I don't go to the doctor and say, I need a new right knee, But that's when we start separating the assets and getting to know how they are titled, that we can advise the client accordingly.
Ricardo, I think you already mentioned some things that are integral to this thought process of titling these assets. Number one, you mentioned in Texas, we don't recognize tenancy by the entirety. So if you are moving state to state and you have titled an account or an asset in one type of joint ownership, it probably behooves you, when you land in the new state of residence, to run these things by an attorney or local counsel and see if the titling from the previous state still holds up. Ricardo, also, we started with three types of joint titling. He brought in a distinction in the picture of that red and blue muddled photograph between joint tenancy and joint tenancy in the common. So therein lies another distinction. And then I think thirdly, like you said, that idea of inventorying and just understanding what, let's not assume the way we've titled property in the past. Let's confirm it and ensure that in your word of the year alignment, that it aligns with what our goals and our wishes are. Tenancy by the entirety is an interesting one. And I know in other states in which we've served clients, we've received input from attorneys that could potentially offer better creditor protection in those other states. We won't talk about that in Texas because it's not applicable. But in terms of titling in Texas, from a joint property standpoint, are there stronger creditor protections with certain choices on joint ownership than others?
Unfortunately, not. for married couples. And that's an issue that I think many legislators are giving thought to, because in tenancy by entirety, that's the main purpose, is to protect the assets. But in Texas, because of community property, and because there's an assumption by law that if the property was owned or created, or the wealth was created during marriage, it's community property. There's a high degree of exposure right there to the creditors of one of the spouses. So if asset protection is one of the goals, there's other ways of separating the assets so you can isolate liability. And that's one of the most frequent questions that I get is, because my wife and I have a joint revocable living trust, our assets are protected, right? No, no. Basically, a revocable living trust just gets you out of probate, but it doesn't afford any more asset protection than what you already had, probably. So, unfortunately, not, Adam. I wish I had an answer that would satisfy those that have joint assets in community property as to how to better protect them. But it needs to understand the situation. One needs to understand the situation and why they want to separate them. It's unfortunately it's on a case by case. So
Well,
yeah.
and I think you bring up a really interesting point in that, right? Is that underlies the opportunity for collaboration and understanding what a client's goals are, again, and how it ties into that. So if asset protection is important, what I'm hearing is, and for our viewers, maybe defaulting to just a joint ownership isn't in your best interest. It could be, but it probably warrants asking a professional. And again, even a CFP, we joke, means expert of nothing. That's when we're getting into legal advice. And so we always want to bring an attorney in on that for matters of asset protection. And again, so what I'm hearing is in Texas, some of those more basic levels of asset protection afforded by property ownership type aren't here. But as we know in working with cases together, there are other ways to get there. You also mentioned, Ricardo, the idea of probate. And sometimes by titling an asset one way, it avoids the probate process. Texas probate doesn't seem to be scary, maybe depending upon the county in which you are. But tell us a little bit more about that. So, are there types of joint property maybe that would facilitate the bypassing of probate? Expound further.
Yes, yes, yes. There's another assumption out there, I think, that all your assets, if you have to go through probate, all your assets go through probate, but that's not the case. Certain accounts and most financial accounts do not go through probate. They go through beneficiary designations. Or if they're joint titled, then there's someone else there on the name of in the account. So that, going back to my word, alignment, how do you own that asset? And another thing that I see very often is like the clients tell me, Ricardo, I opened this account. I put my son in the account too. That way, if I died, it's no big issue because he's going to be able to keep on using the account without any problem. That opens another conversation as to exposure. Now you're inviting your son's creditors into your account, which might not be what you want. So, it, it's that's why we tell people, that's why the inventory is so important, because that way we know which items are going to go out of probate, which items, if we create a trust, which assets we want to bring back. Let's say like putting the trust as a beneficiary so that they go back into the trust and continue serving the family or serving the beneficiaries the way that the grantors of the trust wanted it to be. But I will tell you that in about, I don't know, half of the cases that we see that go to probate, the couple created a trust and they left an asset outside. And it's usually a financial.
Yes. And I will tell you from helping inventory accounts, some banks are hard to find beneficiary designations for. So, in the age of easy online account setup and really fast processes, That is very true on the front end. On the back end, when you're doing the research to go and find what type of joint ownership did I choose? Did I designate a beneficiary on it? You can't always find that online. So sometimes you have to do that thing that we all hate to do. You have to go to the bank or you have to pick up the phone and you've got to call to get it. But it is so important. I think to Ricardo's point, we've seen it where we've been called in as an expert witness on a case where there was a blended family. And when we say blended family, we usually mean children from a previous marriage. So it's the client's second marriage. One spouse passes and they chose to set up an account as joint tenants with right of survivorship, which Ricardo mentioned earlier means those assets flow to the surviving joint owner. They bypass the probate process. They go directly to that spouse. Well, guess who that means doesn't get access to it? The children from the previous marriage. And so there are instances such as that where it doesn't make sense to title those assets with right of survivorship. I think back to Ricardo's key word, because it doesn't align with the client's goals. They didn't want to disinherit their children. The children had a not so great relationship with the new spouse, but effectively that's what happened. In decades, this case has been in court, prolonging the estate process, litigation, not fun stuff. So it's something as simple as account ownership, but as powerful as decades worth of litigation and ongoing estate being open. So, Ricardo, we want to be respectful of your time and that of our viewers. We're 25 minutes in. Give us maybe any other closing thoughts and ideas of what are red flags? What are instances in which joint ownership might not be the right answer, just in general, things to think about as we come back to your concept of alignment.
Okay, first we mentioned liability concerns. If there's some sort of exposure, maybe, and I've found this a lot, is that in the couple, one of the spouses owns their businesses and the other spouse owns their own businesses. Is there some level of higher exposure on one of them because of what they do, or just they're more in a more litigious area of work? Try to think about whether joint ownership is the right way to go if there's any issue with liability. Second, you also mentioned it, blended families. Make sure that everyone that you're thinking about and your spouse is thinking about is going to be taken care of the way you want. You don't, like some of my clients say, Ricardo, I just don't want to leave a mess behind me. I'm like, I totally agree. So let's get it all lined up and make sure that everyone is happy. They're sad that you left, but they're happy that you left everything in order. So that's another thing. And then when you're doing advanced tax and estate planning, you want to take a closer look at joint ownership because it might derail or it might limit the strategies that you can use. It's not that you can't change the titling, but you have to be careful with how you title the assets when you're thinking tax-wise. You also want to be careful of joint titling when you have separate property, because adding a spouse might turn that property into community property, which might not be what you wanted. So that's another issue you have to think about. And going back a little bit to our original point, if you have business or investment assets, sometimes it's better that they are held by entities or trusts and not by individuals to avoid these issues. So that would be my final thoughts to this topic. But if I want the viewers to remember something, is make sure that you know the effects of whatever option you choose, because you want to make sure that that's the outcome that you want.
That's great. And I'm going to follow up on that as the financial professional that is often helping a client open an account. Sometimes when the paperwork is ready to go and they're in the office and they want to sign it and get it done, it's an impediment to the speed with which you execute to go back and get counsel on it. But it is imperative. And again, back to the idea of the age of instant gratification, and I can set an account up in 2 seconds online. That is great in certain instances. It is not always the most well aligned with your plan. So I echo your sentiment, Ricardo. I thoroughly enjoy getting to work with you. It's awesome having you on as our first guest today. I don't know how the Yankees are doing this year. The Rangers seem to be doing okay. I hope to see you at a baseball game again soon.
Yes,
And
yes.
you've hit on like 15 other topics that we should probably have follow-up talks on as well. Thanks for your time today.
It's a pleasure. Thank you for having me, and thanks for everyone who watches and listens to this podcast.
You're most welcome. As far as getting in touch with you, maybe what we can do is put information in the comments section if we're posting this, but any other feedback you want to give in terms of how somebody might contact you to make sure that their account ownership and designations are aligned with their plan?
You can just, I think my name is not very common, so you can always Google Ricardo Ceballos Estate Planning, Texas, or something like that. It will pop up. I think the SEOs are working, and now AI has also found me.
Perfect. Well, we will look forward to the next time. Have a great evening, and thanks again for your time.
Thank you.
Yes, sir.